Hey, out there, legal warriors. A lot of people call our office after being investigated for a crime or arrested for a crime, but they're not charged yet. And the question that I often get is, should I hire an attorney prior to being charged? If you're interested in the answer to that question, stay tuned. This is the video for you. My name's Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, as always, I'm just going to jump right into it. As you might imagine, a law firm of my size and has been around for so long in Washington State, we get all types of phone calls. And depending on the location of a potential crime or the level of a potential crime, oftentimes someone can be arrested for a crime and then released, but they're not charged yet. They can be investigated for a crime, but there's not a decision yet, so they're not charged yet. But yet, of course, people want to get ahead of things. They call a defense firm. And whether or not someone should hire an attorney prior to being charged depends, as you might guess, on many different factors. Now, if you call a firm that's so busy and they don't really have a way to deal with uncharged cases, the lazy answer for attorneys that would be out there is, oh, just call me once you're charged, right? It's easier for the attorney. There's less for the attorney to do. And it's maybe an answer that you want to hear as someone who's being investigated. Oh, good, I don't have anything to worry about. And from our point of view, usually that's not the right answer. Usually the right answer is us asking you questions to figure out, is the right answer yes, these are things we can do now? No, there's nothing we can do now. Or no, I don't think it's any chance of being charged, so save your money. So what do we do if we take a case on pre-charging? How do you make that decision? Well, let's look at two different situations. One is a situation where the police are knocking on your door and they want to ask you some questions about investigating a crime. Well, in that case, as we might guess, you almost always want to have an attorney for that because, number one, we probably shouldn't talk to the police at all. But number two, especially if you're innocent, maybe there's a way that your attorney can help clear things up so it never gets to the position where it's even looked at to be charged. So if you're being investigated by law enforcement, it's a pretty easy answer. Yes, you should get a hold of an attorney. Yes, there's a lot we can do. A whole lot we can do, and sometimes it's just insulating you from the police, right? Hey, don't talk to the client, talk to me. Advising the client, how they can avoid being arrested by law enforcement. That doesn't mean go run, but we also don't have to help them arrest us. That's not our job, right? As if we're a suspect about something. Now, the situation that becomes less clear is where someone's already been arrested for a crime and they've been released, or they're in jail and someone's looking to hire for the person who's in jail but not charged yet. In those situations, whether or not you should hire an attorney is a little bit based upon circumstance and the type of person you are. Are you the type of person that wants the most possible protection to your freedom and your future? Or are you the type of person that's like, yeah, it'll probably all turn out okay? And the tolerance for risk will weigh into what you should do. But what would a defense attorney typically do, let's say on a misdemeanor domestic violence arrest in the county, where in the county case, if you've watched my channel, you know this, usually if you get arrested for a non-city, a county-type misdemeanor domestic violence case, you're going to be held in jail. You're going to typically get released with no bail or small bail. There's going to be like a temporary no contact order, usually for about 3 days. And then if the prosecutor doesn't rush file the case within 3 days, there's no restrictions anymore on the suspect who got arrested. And now we're just waiting for the prosecutor to decide what to do long term. In other words, you get arrested, you get released. They tell you if they don't file a charge within 3 days, then these conditions go away. It sort of feels like the case is dismissed, but it's not. It just didn't get rush filed. And now the prosecutor has to decide what to do with it. And usually now, if we're the person that got arrested, we're terrified, right? We're freaked out. Maybe we didn't do it. Maybe we're sorry for what we did do. Our whole life is flashing before our eyes. And in that situation, there's quite a bit an attorney can do to help. We can help with the actual case, and we can help with the actual emotions and feelings that you happen to be going through processing what happened in this hypothetical domestic violence arrest. When we say help with the case, that means we can do a public disclosure request. We can try to get the law enforcement reports that were sent to the prosecutor so we can have some idea about predicting the future, right? An attorney who's done a lot of cases, decades worth of cases, can look at a report and have a really good idea of what the chances are, knowing the culture of the prosecutor's office involved and the people involved making the decisions whether to charge or not, what the chances are that that charge will actually get filed. We can also have the client sometimes do some things that might improve their chances to avoid getting charged, but that's a very specific case where we would do that. Don't expect your attorney to do that because the prosecutor's not required to listen to your defense attorney in the charging game, right? When it's in their pile, there's no rights, there's no charged case. If your defense attorney has a very special relationship, trusted relationship, build up reputation with the prosecutor's office, and you have something that absolutely clears your client, right? The person making the complaint says they got hit, in Linwood on April 4th, and you have a video and airplane ticket showing that on April 4th you were in Hawaii, right? Well, that would be a smoking gun in your favor. In that case, your attorney could likely get a hold of a prosecutor if it's so clear once we see a report and say, look, you can't charge this because this person is lying. But that's the exception. Don't plan on your attorney doing that. Also, what the attorney can do while the case is pending, if they have access to the right systems, is they can check the system every so often to see if there's any charges on you. That way you can travel. You don't have to worry about missing court dates, things like that. Because, of course, if you do get charged with a crime, no one's going to call you on the phone and say, hey, you're charged. They're just going to file something in court. The court's going to send you a piece of mail. Do you get the mail? Not if you're out of town. Do you get the mail? Not if someone stole your mail. Do you get the mail? Maybe you moved and you don't get the mail. They do not forward those notices, right? They are do not forward. Courts do not forward notices of court dates. And sometimes it takes up to 2 years to charge. Might you move in 2 years? Yeah, you might. So it's like an insurance policy in that way. Additionally, you can get advice from your attorney about how to gather witnesses, how to write down everything that happened while you can remember it, right? Because it's going to be a long time until there's a charging decision. Also, if a prosecutor declines to file a charge, they're not going to tell you. They don't send you a little letter that says, you're out of the woods, defendant, right? The only way the attorney typically finds out is getting a hold of the prosecutor's office in a way that doesn't trigger them to look at your case, right? We don't want to say, hey, please, have you looked at Mr. Smith's case yet? Oh, thank you. No, I forgot about that. Oh, man, I need to charge that guy, right? You don't want that to happen. Your attorney in certain places can get a hold of certain desks and stuff in the prosecutor's office where more of a ministerial person can look at a record and sort of, hey, that was declined on this date. Well, now we can tell you you're off the hook and now you can relax. And that's pretty big value. And additionally, if you do get charged, we can tell you what the court date is and start to get you prepared for what might happen at that court date. So some people want that type of protection and insurance, and some people don't. And also it's a financial decision, right? Where are we financially and what can we afford to do versus what can't we afford to do? And there's different examples besides domestic violence that goes for DUI cases. If you get arrested for a DUI, and you're not charged yet because it's a county case, it's state patrol, or it's sheriff, where it's the same type of situation where they can arrest but not charge. Well, you're still going to need an attorney right away in that case because you've also likely got a licensing hearing to worry about. You've got 7 days to request a licensing hearing, and so you need your attorney to do some stuff. We also, in those cases, try to preserve some evidence that's going to waste and go away, like breath test room videos. Oftentimes there's a video in a breath test room, but they're usually on a hard drive, and those are going to get overwritten. They're not going to get maintained. And the state doesn't save those because those breath test room videos do not help the state, right? The officer just marks on the box, I did everything right? And that's their evidence. Well, oftentimes there's video that might show the officer didn't do everything right. So there's lots of reasons to have an attorney prior to being charged. It's not absolutely necessary, but if you would hire an attorney if you're charged, you should look into the options of hiring an attorney before you're charged because many attorneys will quote a lower rate to deal with an uncharged case, and then credit that money towards defending a charge case should it get charged. That's at least how we started doing it, and how some of our friends in the legal industry do it as well, but not everybody, right? Some people will charge a full rate as if it gets charged and then act the hero if it's not, and then it may end up have overpaid, although that's not what this video is about. Many different attorneys do things different ways, but there's plenty of reasons that you want an attorney prior to charging. Now, why don't you want an attorney prior to charging? There's some reasons why you don't want one. Yeah, I can think of several reasons why you don't want an attorney prior to charging. The first being the case is just so stupid that you don't need one, right? If you were to call us up and tell us a story about you went to a certain store that we know doesn't report things to the police, and you shoplifted $50 and the police never showed up, right? And they never gave you a police report number, and you call us and we say, yeah, we know as a matter of policy that particular Hagen store doesn't call in the police for their own reasons. Well, you don't need an attorney then, right? We wouldn't let you hire us. Another attorney might, because either they're trying to get a case, or more likely they just don't know because they're not big enough to know, right? We don't know until we learn, right? That's a time when you're not going to want an attorney. Sometimes you don't want an attorney because if the other side learns you have an attorney, you're a victim or something, and they hear about it, that might make them more aggressively try to protect their position by reaching out to the prosecutor. Now, you can mitigate against that by hiring an attorney and sort of keeping it quiet, right? But a lot of these domestic violence cases involve divorces and custody issues, and sometimes if there's a criminal arrest and you guys are trying to work out the family law side without having to spend $20,000 on a family law attorney, and they hear you got a criminal attorney now, that can create a lot of anxiety in someone. So I can think of that's a reason also. Human relationships are complicated. But for the most part, my rule of thumb is if you can find a firm that's willing to help you, that seems to be treating you fairly and honestly, and you would have an attorney if charged, if an attorney offers to help you pre-charging, it's usually a good idea. I can tell you for our firm, we're pretty busy, right? We're in very high demand, and we do feel more committed to a client that I think in general, if you get a hold of us 8 months before you're charged, well, we've known you for those 8 months and worked with you for those 8 months prior to being charged. Maybe we help lessen the charges, help prepare you, but we also have a relationship with you now, right? And building that relationship with someone you're trusting to save your life is pretty important, right? And not all firms are like ours, but if you were to get a hold of my firm and you talk to us and you say, yeah, we don't need you pre-charging, we're probably not very likely to take your case once it's charged, because we already sort of figured out that maybe, we don't need each other, right? That type of thing. So, everybody's going to have a different opinion. I always be as transparent as I can in these videos. But I think that, out of every 10 calls we get for pre-charging, we probably offer to help 1 or 2 people. And usually most of those people will take us up on our offer, because we're only going to offer to help if we see a reason to. So I hope you found that useful. If so, please like and please subscribe. More people will get to see it. More people get the help they need. More importantly, if you got a criminal problem in Washington State, feel free to give my office a call. Be good on board. We'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.